first case today is Russ v. Kracht. I'll be listening for the correct pronunciation of that from counsel. A couple of notes before we begin. We've allocated 20 minutes to a side, but we're still asking questions. Please continue to respond. You need not ask permission to do so. Okay, I think that covers it. I think we're ready to get going on this one. So I'll ask counsel to enter appearances and then we can begin.
Alexander Marshall for the appellant in Kracht v. Ross, and then Emily Adams for the other appellant in Kracht v. Ross, and also the appellant in Call.
Welcome.
Taylor Webb on behalf of the appellees Julie and Gerald Ross.
Welcome to you as well. Okay.
May it please the court. Termination orders are always final. This court should apply the same principles of finality to the district court termination orders as it does to juvenile court termination orders, because the analysis is the same. This is not an exception to finality, and this gets murky through the case law, but this court's precedent has held that this is not an exception to finality, the rule that has developed in juvenile court. It is just the application of finality to the unique procedural circumstances that happen in a court that has continuing jurisdiction and multiple petitions resolved at different times. So the same thing happens in district court in adoption proceedings. Adoption proceedings are special in this way. They are governed by the specific procedures of the Adoption Act, and you have petitions within the proceedings. So you have adoption petitions and termination petitions. The termination order fully resolves the termination petition and resolves all of the claims as to all of the parties for that petition. And that's why, just like in juvenile court, they are also final and should be considered final for purposes of appeal. This is best laid out in this court's decision in ACM 2009 Utah 30, but it does go back a couple of decisions. And we looked all the way back to sort of the origins of where this came from, how finality developed for juvenile court. It's much more developed in juvenile court. There's very little case law for the district court analog of this for adoption cases. Pretty much the only one is in Re CC that touches on tangentially how finality works in district court, but doesn't quite get to the heart of how a termination order should be handled, because that was not a termination order. That was a motion for summary judgment, and that parent was not actually a parent at that point in time legally. That parent was looking to establish rights, and the court denied them. Sorry
to interrupt. So is it fair to say that we have never said, as the district court proceedings, that a statutory exception must be expressed?
That this court's never said that?
We've never said that with respect to a district court adoption proceeding.
I don't believe this court has ever said there must be an express exception. I mean, that's finality case law from other cases.
It looked like the Court of Appeals was anticipating that, kind of reading the tea leaves, and they said it. But okay, I think you've answered my question. Thank you.
Okay. So there is two alternatives here, and I think maybe this is getting more aware.
Well, I could ask this, interrupting again, but what's the closest we've come to saying that with respect to the statutory exception
in adoption
cases in district court proceedings?
What's the closest you've come to saying that there needs to be a specific statutory exception in district court adoption cases?
Yes.
I don't think it's ever expressly been addressed.
Okay.
Because we've never had that procedural circumstance come up. It's been assumed to be final for so long that it's never really come up. And even in KRS, that was a sua sponte motion of the court that brought up the finality issue there. It wasn't even brought up by the parties. So it's just simply never happened. And certainly never gotten to this court in the district court context, because it's just followed the juvenile court rule for so long. And of course that rule being that it must affect a permanent change in the status of the child in order to be a final order. And that works really well for all of the precedent that we have to deal with. So if we were to apply that rule to in re CC, the same outcome would have happened. It would have come out exactly the same because that motion for summary judgment did not change any permanent status as to the child because that parent never had rights. So it didn't terminate anything, didn't change anything. That would have proceeded exactly as it did in re CC. So the rule really is workable. And I keep calling it a rule. I just want to make sure it's not an exception. That's our first argument, is that it's not an exception. It's just the way we're applying it to these proceedings. This court could make an exception. That was the other solution contemplated in KRS, where you just articulate a different rule for these special kinds of proceedings, that a termination order is always final because of the fundamental liberty interest at stake and the judicial economy vis-a-vis dealing with the best interest of a child. We really don't want a situation where we are waiting all the way for an adoption to happen, which the child needs to be present at an adoption hearing. They have to be in the court. So they're hearing that they're adopted, and then there's an appeal. And if for some reason the termination order underlying the adoption is successfully challenged, then that adoption is undone. And that's confusing for a child. We don't want to put them in that situation. There's no reason to. It actually doesn't save us from multiple appeals because the parent is not going to appeal both the termination order and the adoption decree. They can't. So it's only ever going to be one appeal. It makes much more sense to do that appeal at the termination point rather than waiting for the final order and adoption, which is why litigants have proceeded that way for the last 20, 30 years, for as long as we've been doing these kinds of adoptions.
From your perspective, is there an advantage of having this court rule that a termination order is simply final, as opposed to having this court rule on the statutory basis that you've articulated?
I think it's easier, frankly. I think it's easier if it's just a simple, if it's a termination of an order terminating parental rights, it is final. I can't conceive, and I've tried, I can't conceive of any circumstance under which a termination of parental rights order would ever not be final. There's no reason for it to not get there, other than you have these courts with continuing jurisdiction, and then things happen after, like an adoption or review hearings, depending on what court you're in. So it's really just this continuing jurisdiction piece that sort of throws a wrench in the finality, what is obviously final, of a termination order, which is why the court in KRS said basically this would always satisfy a 54B certification because it's a termination order. I mean, you don't get much more final than that.
I have a question about the finality thing, but let me stick to this other point for just a moment. So I'm intrigued by the argument that we just define action as the petition itself. I'm trying to think in civil proceedings, though, are there other cases where you might have multiple individual petitions within the same case number? And if so, I was trying to think of an example, and perhaps my imagination was too limited as I was thinking about this over the weekend. But if that's the case, then why wouldn't the rule that you're proposing apply to all of those types of cases where there's more than one petition within in a particular civil case?
So I won't claim to have comprehensively figured out every single case in which there could be multiple petitions, but one area of law that does have a similar thing is bankruptcy law. And there is a great case from the U.S. Supreme Court. It is Ritson Group v. Jackson Masonry, 589 U.S. 35. And I'll just read the paragraph there that I think if you just sub out the word bankruptcy for adoption, it would make a lot of sense. The ordinary understanding of final decision is not attuned to the distinctive character of bankruptcy litigation. A bankruptcy case encompasses numerous individual controversies, many of which exist as standalone lawsuits, but for the bankruptcy status of the debtor. It is thus common for bankruptcy courts to resolve discrete controversies definitively while the umbrella bankruptcy case remains pending, delaying appeals from discrete controversy resolving decisions in bankruptcy cases would long postpone appellate review of fully adjudicated disputes. Moreover, controversies adjudicated during the life of a bankruptcy case may be linked, one dependent on the outcome of the other. Delaying appeal until the termination of the entire bankruptcy case, therefore, could have this untoward consequence. Reversal of a decision made early on could require the bankruptcy court to unravel later adjudications rendered in reliance on the earlier decision. So very similar relationship. You have these controversies within the larger case. And I don't know bankruptcy well enough to say whether that's always initiated by a petition or how that works, but the same structure applies, where you have these multiple controversies within the larger proceeding that are fully resolved. Sometimes they're interdependent, and it just makes more sense to appeal them right then and there. So those are appealable. Each one of those is appealable directly. You don't have to wait for the
Well, that is
proceeding.
a perfect segue into my other question, which is whether juvenile court proceedings, though, are different in terms of the continuing jurisdiction. So when you're talking about bankruptcy, you're saying that they have, the bankruptcy court has continuing jurisdiction over the debtor. And I can see the analogy to juvenile courts having continuing jurisdiction over the child, right? But does that work the same way in district court? I mean, when we said in ACM that, the difference in terms of how we treat the finality of termination orders stems from the unique nature of juvenile court jurisdiction, which often continues after a final judgment is rendered. What does that mean? Is that how far does juvenile court jurisdiction continue?
So in some cases, actually less far than district court, because
Okay.
juvenile court terminates its own jurisdiction at the conclusion of the case. So once an adoption decree is entered, for example, if you have termination and then later an adoption decree is entered, jurisdiction continues to that point. But once that adoption is entered, the juvenile court terminates its jurisdiction. It's done. Exactly like a district court adoption. So district court will maintain that jurisdiction until the adoption is entered, and then it's done. There are cases where district courts have continuing jurisdiction that goes on kind of forever. So family law courts, for example, have continuing jurisdiction over a family law matter. Anytime there's a new petition to modify, it comes into that same court. So that continuing jurisdiction piece, although it doesn't look exactly the same, juvenile court jurisdiction is over the child. It's a little bit more idiosyncratic in that way, that it's really following the child, and that's why you have multiple people under the same case number and things like that. The idea for finality applies the same way, because you have the same thing happening, where the court just has jurisdiction beyond what we would consider the final order, in this case the termination order, in order to effect the next step. And that's not necessarily a problem for finality all the time. We consider orders final even if a court has continuing jurisdiction over enforcement, like family law. So that doesn't make a divorce decree not final. It can be enforced later. We don't have any problem with that. It's just the idea that there can be another order entered that relies on the earlier order. But it's important to note that in district court proceedings, for example, there cannot be a standalone termination petition. It cannot exist without the adoption petition. So the finality in terms of the separate petitions, it always has to be that there's a termination and then an adoption. You can't, unless there are no one intervenes, there are no parents, but whenever you have a contested adoption, it has to go in that order. And so that jurisdiction will always happen in that way.
Do you know if it's usually the case in district court, if you have a termination petition and an adoption petition joined, after the district court decides termination, do they normally wait for the time period of a notice of appeal to run before setting the adoption? I guess under this rule, you'd have to, if we were to say that, and maybe this is already the practice, I can't remember, but it seems like that's what you'd need to do. Before setting an adoption, you'd have to wait for the period to expire where the person whose parental rights were terminated could file a notice of appeal. And I don't know if do you know if that's the general practice right now?
Yes, that's the general practice. If a termination order is entered separately, they can be entered in the same order. It can happen, but not generally. If a termination order is entered earlier, the court generally waits that 30-day period to pass. And then if an appeal is filed, the court stays the adoption proceedings usually stays the adoption proceedings until that appeal is fully resolved. So that is the practice right now. That is why KRS sort of upheaved quite a bit of the adoption practice because everybody had always assumed that's how it was going to work, and then all of a sudden it didn't. So that is how it works. That's what they usually do.
Can
And
I
that's
ask-
regardless.
oh,
Go ahead.
A follow-on on the questions that Justice Hagan was asking. So in ACM, we said that the nature of juvenile court jurisdiction is unique, but it sounds like from your answer, it's not terribly unique. Is that right?
It has unique features, but for the purposes of a finality analysis, it's not.
Okay, so we might have been wrong about that.
I don't think the court was wrong about that. I think they just weren't thinking about, or we just weren't thinking about the district court version of this. What the court was focused on was, what do we do when we have a situation where the court has continuing jurisdiction, there are parties left, there are things left to resolve, but you have this order that is dealing with fundamental liberty interests and really delineates the rights of these parties in a way that is permanent and changes as to the child. That is exactly the same in the
I know,
district
it just sounds to me more like an exception than it does an actual reflection of the uniqueness of the jurisdiction, or I'm not really understanding how the court was interpreting the word action in one setting one way, but in another setting another way. I'm struggling with that. I'm struggling to figure out how to apply it because I'm just not sure its underpinnings have a lot of merit.
Looking back in the cases that came before, so MW 2000 Utah 79 has a piece of this, and then it goes all the way back to the 80s, and most of this evolved actually out of Court of Appeals decisions, which is not surprising given how the jurisdiction works.
Sure.
But once it got to the Supreme Court, that's when we see this delineation based on action, and action being a petition. And that's kind of the best way we can organize it, is to say where you have multiple petitions. So in juvenile court, the version of this is an abuse, neglect, and dependency petition resulting in an adjudication order. That's final. And then a termination petition resulting in a termination order. That's final. Everything in between, unless it permanently changes the status of the child, not final. And it is admittedly a more complicated application of finality. That's absolutely true. But it's just a more complicated proceeding in terms of the moving parts that are happening and the way the parties' relationship to each other is in juvenile court. It is the same in terms of the termination versus the adoption in district court. That evolution is not as developed just because it hasn't happened.
Sure.
But the same principle, if you take the same principle like resolving a petition as the action, then that principle applies pretty cleanly, probably more cleanly in district court than it does in juvenile court. In juvenile court, you can actually have final orders that don't originate from their own petition. So that one's a little bit messier actually, but in district court, it's quite clean because there's really only two types of petitions. It's the termination petition and the adoption petition. So you'll
But then
only have
don't we have to then, I mean, what's the rule we come up with there? Because it seems like there are cases, just ordinary civil cases, where you might have a third-party claim or some other claim that absolutely resolves the issue as between that party and the rest of the case. And we tell that party, well, you've got to go use 54B if you want to get your appeal up, right? We have a procedure in place for people to use that. And so I'm just trying to figure out a principled way to say, well, we define action differently. Well, what's the definition of it, right? Because otherwise, I'm not sure how it applies in a different setting, even though I think for all the principal reasons you say, maybe it should. So I'm just trying to figure out why 54B just doesn't take care of this for everyone, or why we carve out this unique way of interpreting action in a few distinct cases.
So a couple of answers. I think the first answer is maybe more what Justice Hagan was getting at, is it might just be simpler to say in these proceedings, here's the exception. Termination orders are final.
And I guess I know you have other answers, but why wouldn't we just create a rule then that makes that exception as opposed to putting it in our case law?
I think it's kind of 6 one, half dozen the other.
Yeah.
This court has made exceptions before. Intervention, for example, is one of them.
Okay.
Either way will work. We will follow it either way. I guess is the point of that. But to get more into the mechanics of what you were talking about, and I've lost my train of thought.
I'm sorry, I
Nope,
totally
it's okay,
interrupted you. No, it's.
I'll get it back.
just thinking about how we would define action or how we would principally define it in a principled
right.
way so that it doesn't just,
Thank you.
and why 54B isn't that.
So this is about drawing the distinction. I see it as drawing the distinction between what happened in Ray Heater and what happens in ACM. And in Ray Heater, it was this talk of a pragmatic approach, right? So we're going to look at the substance of the order, and we're going to have this pragmatic approach that looks at whether an important thing has been resolved. And that is a much more subjective, in some ways, analysis than what we're doing here. Here, defining action as if there was a petition that is fully resolved, all of the facts and claims in that petition are resolved, then that's a final order. So I think that's the cleaner way to delineate between those two. You don't have that situation, and I don't know all of probate, but you don't have the same situation in probate where you have multiple petitions being filed in the same overall proceeding, so that you could delineate each one of those as its own action. I think that's what the court was trying to do in ACM, was trying to draw that line. Admittedly, I would have liked a little more analysis on that, but that's the way we have it. That's the best way I can state the difference between those two, is you really have this concrete idea of a petition, which we generally understand as the beginning of an action, as opposed to a motion. And that's, again, lines up really well with the precedent in Ray CC. That was resolving a motion for summary judgment, not a petition, so you wouldn't have that same problem with that case. You wouldn't have it in other traditional civil cases where people are filing motions, you have multiple parties that are coming in, but one's being completely dismissed from a proceeding, but they're doing that all on motions, not petitions. They're not separate proceedings.
Can you envision, though, that maybe there's a time where someone files a complaint, third-party complaint, some other pleading, that perhaps if we look at it, we would say that's related, so they can file it in this case, but it's completely separate?
Yes, and so that gets me to the second point that I think is different and that this court can articulate that's a little bit different. And this admittedly feels a little more exception-y, but I would say it's because we're dealing with the best interest of a child.
Sure.
And that we've just always yielded to that. That's in case law, in ACM, in MW. We see that theme repeated, that the principles of judicial economy are going to yield to the best interest of the child. So that's what we're doing here. And to the extent we need another fence around cabining this, that's your other fence.
Okay.
So would your argument be that we should adopt a rule that whenever a separate petition is resolved in a civil case, that is a final and appealable order? Or would your proposed rule be that that rule only applies in termination cases or cases involving the best interest of the child?
I would imagine that this court would be more comfortable with the latter, just to keep that from being applied in unintended ways. That is twofold. It is, we are construing action narrowly so that a petition that is resolved in either an adoption proceeding or in juvenile court is final when that whole petition is resolved and it changes the status as to the child.
Okay.
Because we're dealing with children.
And as you said, that does sound more like an exception.
It definitely skirts that line. I think ACM really tried to make it not an exception. And there is a thread there that makes a lot of sense from the structure of the way these proceedings go. But it does get blurrier in juvenile court to apply it in that same way. Again, I think district court is actually much easier to do that with, but juvenile court can get a little blurrier. So if this court wants to just articulate a clean exception of termination orders are always final because of the fundamental liberty interest involved and the interests of the children, that makes perfect sense as well. It's probably the easier and cleaner way to go, but we gave you different options because we weren't sure which one you'd like. So that's our arguments here. I don't think an exception, creating an exception that outside of just that clean termination orders are final makes much sense, because then we get into the difficulty of how do we apply it in every single case, and it becomes much more case by case, which is what we don't want from the NRA Heater decision. But a clean exception or an exception delineating action very narrowly, I misspoke, a rule delineating action very narrowly that is not an exception would probably avoid those situations.
If we said in case law that in the district court, when a termination petition is finalized, it will generally need 54B. So normally, I'm not sure if in practice it's happening, but we've been a little bit picky that we don't want, in the general case, a district court just saying 54B is met. and sending it up on appeal. We want them to give their reasons. But here with 54B, like you, I can't think of a situation in district court where it wouldn't be met. Maybe there's something I'm not thinking of, but it's hard to think of it not being met after the termination petition is finalized. And so if we said in case law, generally 54B is going to be met. If there's some odd case, someone can argue that in an individual case, but the district court in these types of cases is free to just cite 54B and send it up. Are there problems with that approach in your position?
Yes. So there's a couple problems. One of them is just a practicality problem. Usually parties in these proceedings on the parent end are represented by indigent counsel. They'd be represented by different appellate counsel if they tried to appeal. So there can be a gap where functionally a 54B might not be requested. If it's automatic, then it sort of leads to the conclusion of why not just cut out the middleman and say it's final, and that way we don't have any confusion over it. We don't have a possibility of appellate rights lapsing because a party didn't understand they have to do that or something along those lines. It's mostly for practical reasons. There's also aspects of the adoption code and the way notice happens after that entry of a termination order that make it more difficult, because pretty much the second that termination order is entered, that party is not only legally dismissed from the case, but practically dismissed from the case. They cannot access anything. It disappears from their green filing, it disappears from exchange, they cannot see it at all. So they don't know what is going to happen afterwards. Usually an attorney can still squeeze in, a motion for certification, but it just requires an extra barrier. It just sets that extra barrier for parties that are already usually indigent and not sophisticated to make sure that they perfect their finality and then appeal within the allotted amount of time, which is hard enough usually for those parents. So it seems that if the rule is just going to say, well, it's always 54B, then it seems more prudent and more efficient to just cut out that step and say it's always final.
Can you help me understand why that route to resolve this problem is superior to saying the Adoption Act already contemplates that termination orders are final?
With that one code section that calls them final, I don't think it is. I think that's certainly a great alternative to ruling a whole new thing, is to say that it already contemplates they are.
I may have misunderstood your answer to Justice Hagan's question earlier. I thought we went down this road because you said this was a superior way to deal with it, but I may have misunderstood.
You meaning the exception, like a blanket exception?
Right.
I mean, it's cleaner. It's cleaner to say that. It already exists in juvenile court, so I guess it's kind of the same answer. It's just how the court wants to get to that destination. If the court wants to get to that destination by saying the Adoption Act contemplates that the orders are final because it calls them final, so they're final, then that's a perfectly fine way to do that. If the court wants to articulate a blanket exception that applies to both juvenile and district court, it's a little bit redundant for juvenile court. There's no circumstance in which a termination order is not final in juvenile court, but it might be just a cleaner way to do it. I'm not sure one is superior to the other, but one definitely has statutory backing.
Thank you.
I see the one roadblock to that is that we have said in case law that to recognize an exception to finality, it needs to be expressly stated in statute. What do you take from that statement from our case law?
So this was the concern of the court in KRS, and I do think that it's not as express as it could be. Absolutely, it's not directly going to appeal. But looking at the language and the fact that it calls both a termination order final and an adoption order final, what else could that be referring to, if not appealability?
I mean, I think I tend to agree with you as far as interpretation goes, but I'm just, if we're bound by the statement that we made that it must be express, I don't know how I interpret that to be express. And so I guess I'm wondering if you think we meant that when we said it has to be express. I mean, just trying to figure out where that comes from, and if in fact we can require the legislature to express its intent in a certain way.
That probably has more slippery slope implications than just articulating a blanket termination orders are final. So that maybe that's the answer to your question, is saying that this is an express statutory exception would open that door a little wider for other areas of the law where the legislature happens to use the word final, and suddenly whatever those orders are become final.
You know, this goes back to my first question. I asked you if you were aware of a case where we have said this must be express. Court of Appeals said this is not express enough. And I'm just interested in, and it seemed to me the Court of Appeals was basically saying, we sense that this is the direction of the Supreme Court. A statutory exception must be express. And I'd like you to direct me to where we said that, or if we haven't said that explicitly, where have we suggested that was the closest we have come to saying that?
Well, the short answer is I think I just took the Court of Appeals' word for it that you said it. But I mean, they're citing Meller for that proposition. We haven't looked deeply into the history of that development, other than just taking it at face value that express generally is much more specific than what we have in the adoption code. That's certainly something we can look into more and provide this court with additional briefing if that's the direction that makes sense. We just haven't looked down that particular line of cases to see if there's more flexibility in that standard. In some ways, it seems like it would be hard to have a lot of flexibility there because it does open the door to a lot of finality if it just has to be sort of implied or something short of express. And the logic of the decision in KRS does make sense in the sense that part of the adoption code doesn't seem to be necessarily getting directly at appealability, but does contemplate at least the implication that the legislature was assuming that those orders were final. So even though it's not creating an express exception, it's not saying these orders are appealable, because otherwise they wouldn't be. It's almost as if everybody assumed they were and moved forward from that position, and the legislature, like everyone else, believed that those orders were final and so appealable.
I think it's arguably express anyway, but it seemed to me to be the central holding of the Court of Appeals below, that this statutory exception simply was not express
Enough.
If I can follow up on the Chief's question, and sometimes the way we approach these questions of statutory interpretation is with presumptions, and I'm not aware of many presumptions where we require something to be expressed to trigger the presumption. Normally, when we phrase them, it's in terms of clear statutory signal or something like that. So, we assume that the legislature doesn't intend to abrogate common law without some clear signal. And so if the standard that we articulated back in 2012 was aligned with the way we normally talk about these, instead of talking about the legislature having to be express, but having to provide a clear signal of its intent, enough to overcome the presumption, so we could presume that they don't intend finality, or we could presume they don't intend to make something immediately appealable, absent a signal of that intent. What would you argue from the Adoption Act provides a signal of that intent?
So as you were giving me that question, I was thinking of retroactivity, that's the other area.
That's another place, yep.
Where you see that express, you need the express intent to make something retroactive, because the presumption is that it's not. So overlaying that analysis, what I would say is the Adoption Act assumed, because of the nature of termination orders, that they are final and called them final. And so there was no express exception needed because it assumed, the presumption was they are.
So you would say that but by using the words finality there and the structure of the act is enough to overcome any presumption that they did not intend for these to be immediately appealable?
Yes.
If we phrased it the way we phrased other
Yes.
statutory interpretive presumptions?
Yes, so the legislature was already assuming they were final and naming them as such. So it did not put in an express exception because it didn't think it needed to. So it's the best.
So you wouldn't say that there's kind of a standing presumption that things aren't final unless the legislature says they are. You would look at it on a case-by-case basis to say, in this particular situation, the legislature would be aware that termination orders in juvenile courts are final, so therefore they would presume them to be final here in district court. I mean, that's a lot to kind of import into their minds, right?
It does sometimes seem like a snake eating its own tail, where you could keep going around in a circle. One thing to notice with the Adoption Act proceedings is the legislature allows two different ways for this to happen, right? So it can be joined,
Right.
or it can be separate.
Sure.
So a separate proceeding, no one is going to debate that one would be not final if it was a separate proceeding. I think that's where we get a little bit clearer indication of why the legislature would have assumed in this specific type of proceeding that a termination order is final, because it's giving these two options. And it uses the word joined, and we talk about this a little bit in the brief. It uses the word joined, which is not the same as this is all like completely the same proceeding coextensively. There's no individual identities. It is still implying that there are separate identities within these proceedings. They're just procedurally consolidated in this way, not substantively. So if we look at it that way, it makes sense as to why the legislature just presumed that termination orders would be always final, because it was talking about them even procedurally in that way. So that's one way of making sense of why the statutory exception never came into existence, but that the legislature still presumed them final outside of the general presumption that orders are not final unless they say they are.
So KRS was the first case where an appellate court had held that they were not final in a district court proceeding, is that right?
That's right.
And before that, we just hadn't spoken on it. So if I understand your argument correctly, you're saying that, you know, there is this expectation, I should say, maybe, that where the legislature is attempting to overturn our case law, that we would expect something kind of a little bit more direct, but that here there wasn't any case law that they were trying to overturn in saying that these orders were final, that was at least arguably the status quo of how things were working.
Right. I think had there been a case that came out earlier that had said this is not final, we would have seen an express statutory exception come into being, because it just makes so much more sense from the policy perspectives and the way that these cases work. So that's more indication that the legislature's intent, or at least their presumption, was that they were already final and they did not need to say anything else on that. The court had never indicated anything else on that. And all of the case law that the legislature was seeing, even though it was out of juvenile court, was that termination orders are final. So there was no reason for the legislature to ever think differently.
And I guess then no reason for them to speak on it.
Exactly.
I mean, it kind of goes both ways.
It does.
Right? If this is so obvious, then why do they need to say anything? And so I'm not sure we read that as intent to set a rule. On the other hand, if they were trying to overcome something, they weren't very express about it. So, I mean, I think it's a little bit tricky to figure out.
It is tricky.
Where you start from and then how to interpret what they did.
Other than their use of the words final, I mean, they put those in, they're not
Sure.
superfluous. There is something about that they're communicating in terms of this is at least what we think the character of this order is, regardless of what the implications of that are. I think that's a really strong indication in the direction that we're talking about, that there was this presumption that termination orders are always final. But that is why I think that's why even ACM is parsing this really finely, to be able to come up with a thread that works within the framework of traditional finality, but still satisfies the needs of these kinds of unique proceedings without opening the door to all kinds of finality shenanigans in other areas of the law. So,
And getting just to that really quick, I don't want to belabor this, but do you see any reason for us not to just adopt a rule that gets at this? I mean, is there a downside to just putting something in our rules about this rather than trying to figure out a way to maneuver through these principles we have about finality that are in the case law?
my instinct is to say that it would be better as case law rather than rule, because the rule, mostly this is the way the rules are separated. You have child welfare rules that are in their corner, and then there's everybody else, and the district court proceedings fall under the everybody else, so you would have to have a specific exception under the normal rules, and then also one further down in the child welfare rules.
But you could have it in both places. I
You
mean,
could have it in both places.
then
yeah.
everyone's on notice. No one has to search for case law.
Yeah, it's true. I mean, I think they're going to be on notice anyways, but this one has been closely watched. And it may be that this also makes its way into a legislative exception. Who knows? But that, either way, I guess is the way to say it. But I would prefer, just from a practitioner standpoint, a strong pronouncement from this court saying that that's where that should go, so it doesn't get lost.
Sure.
Because it's a really important piece.
If we were to go that route and look at adopting a rule on this, what would the impact be on these 3 cases that are pending?
So that's when we would ask for the same thing this court did in Ray Heater, where you just don't apply this retroactively. These cases were filed before KRS came out. All the parties assumed finality. We made it all the way to certification here, and then sort of the bottom fell out.
Sorry, I'm actually asking the opposite question.
Okay.
If we were to say that under the state of the law right now, these are not final, but that we see good reasons for making it final and are going to adopt a rule that says these are final, what impact would that then have on these 3 cases?
Yeah, that's what, so in here, you just didn't apply that ruling retroactively. So that case still proceeded on the merits. We would ask that these cases still proceed here on the merits.
Sorry,
We
my hypothetical is if we say that the current state of the law
Oh, okay.
is that these are not final.
Current as of KRS.
No, the current,
Or that it just always was. It never been final.
Never
Okay.
been final.
Yes, I'm following now.
Then these 3 appellants, I assume, would not be able to appeal? Would they still be able to get a Rule 54B certification, or would they just be out of luck? And our rule would only apply prospectively to appellants in the future?
No, I think the relief in Heater still applies, because that's exactly what happened there, is this court ruled that these are just not final,
Okay.
ever. They've never
Okay.
been final.
Sorry.
We're disavowing this pragmatic approach, but the parties have relied on it up to this point. The cases were filed prior to this case law happening, and so we're going to allow these ones to go through, but further, prospective cases are not final.
But I think to further that, I mean, that would be your preference, obviously, if we went that route.
Yes.
But you could still go ask for a 54B. There's no time limit on it, right?
Not that I know of.
Okay.
It's just pragmatics.
Sure.
Thank you very much.
Thank you, counsel.
Good morning, Your Honors. Taylor Webb on behalf of appellees. Candidly, I don't have much to add substantively here today. I'd just like to emphasize kind of along the lines of that last point that in the event the court were to disagree on the jurisdictional piece, that we would just ask that the court then either construe this appeal as an interlocutory appeal or allow us to seek 54B certification, or do as it did in Reheater and just apply the jurisdictional ruling prospectively and allow us to proceed, because we are sort of fairly far along in the process, and I think it's in everyone's interest to continue these proceedings without having to return to the district court. Obviously, we will do whatever the court deems necessary, but that would be the preference of appellees as well.
Was the notice of appeal filed in sufficient time that we could construe it as an interlock?
Yes, Your Honor.
Okay.
Beyond that, unless the court has any further questions, again, I truly don't think I have much to add substantively here today, and so if there are no questions, I'm happy to submit on our appellant's brief.
I'll just ask one question. Do you see any advantages of us resolving the case one way or another in terms of relying either on a statutory exception to finality, or construing action differently, or even adopting a prospective rule?
The only differences practically that I can see are just adopting whatever path the court takes obviously articulating something that's clear enough that it doesn't, open the Pandora's box that we don't want. I think that this is such a self-contained little area that it's easy to do that in a number of different ways, and I think any of those, as far as I can tell, have about the same impact. So I think the only fear we would have would be just the implications more broadly if the court isn't narrowly tailoring that. But like I said, I think this is such a self-contained area that it could be as simple as just only orders terminating parental rights are deemed final under an express, whether we deem that to be an express exception under the statute or just this court's exception. But I don't think that limiting it to termination orders, I think, is the best practical way to avoid this kind of bleeding unintentionally into other areas.
So you wouldn't advocate for a rule that all judgments from resolving a particular petition are final judgments?
I don't think so. I think that's much broader than what we need and would tend to sort of create a little bit of chaos, much in the same way that KRS has now created chaos, undermining what the general understanding is for practitioners.
Do we have the room to maneuver under the Adoption Act to create a rule? I mean, do we run into problems that perhaps the legislature has occupied the field here and not left us the opportunity? I mean, because in essence, we'd be taking the language from our case law that suggests that something has to be expressed in statute and amending it to say express in statute or rule. Can we do that?
I think I was looking at a little bit of the case law while I was sitting there, and I think that the way that the Court of Appeals at least has interpreted expressly authorized is just where the statute itself says an appeal may be taken from rather than the order itself being final. I don't know that the legislature here has foreclosed the court weighing in on this. Ultimately, you would be interpreting the statutory language of the Adoption Act, which is obviously this court's purview. I think the problem there might be more in line, I guess, with avoiding the Pandora's box situation, right? Where if we're saying that the statutory language here is sufficient, does that open the door to other areas that we're not contemplating? Which is why I do think that if the court is limiting this to specifically termination orders, that's probably the cleanest approach to avoid any of those future pitfalls, I suppose. But I don't think that anything in the statute forecloses this court from determining that the language itself expressly authorizes, because that's just a statutory interpretation question.
I'm trying to think of other situations where you have a proceeding. I think the way this normally would happen in the district court is there's an adoption petition filed. And first you have to go through the preliminary steps, and one of those is making sure that parental rights of anyone who is, so if a stepfather wants to adopt a child, that the biological father either defaults and doesn't respond, gets notice and doesn't respond, and so you wait a period of time for that, or waives his parental rights, so then that takes care of it. And if not, if they join the case and they protest and they object to their parental rights being terminated, then a new petition is filed to address that. And it makes sense for it to be joined, and generally would be joined in that case that's handling the adoption petition. But it's this new petition that's been filed and joined with that case, and you have to handle that and finalize that before you can move over to the adoption. And I'm just trying to think of any other situation where sort of a new petition is filed in an ongoing case. And I guess this could fall in the, unintended consequences, things we don't know that we don't know. But can you think of any situation where it's an entirely different petition that's filed within a case that's already ongoing?
I can't, Your Honor, other than, I guess, potentially the bankruptcy situation that counsel already pointed to. And I think that another reason why, again, this makes sense to limit to termination orders is because even if you can conceive of another scenario in which there may be a petition filed in an ongoing proceeding, I think what's unique about termination orders is something that counsel also hinted at earlier, or pointed to earlier, which is it's not simply you're now, the equivalent of a dismissed party still receiving notices of the proceedings. You're now in a position where you're not only not receiving notice, but you don't even have access to view the proceedings. And so I do think that puts those particular individuals in a pretty sort of a precarious position in terms of preserving rights, where they are expected to, or if the court were to require them to appeal from an order that they're not only not receiving notice of, but won't have any way of knowing exists.
Right, they're not part of the proceeding anymore, really.
Correct. Not only not, and again, at a level that's different than just a normal, dismissed defendant in a multi-defendant action type of scenario. This is, those defendants in a multi-defendant case are still able to, at a bare minimum, access the docket on exchange, but are getting notices presumably even through green filing. That's just not the case here, and I think that's kind of a pretty important distinction that just goes along with why this makes practical sense to treat termination orders differently. Among the many other reasons that have been articulated, I think that piece is pretty important.
And I don't know, the termination is really a condition precedent to the adoption. And so it seems like waiting the time for the notice of appeal, that still may not be final. The termination, if they decide to appeal it, may not have been completed in order to move on to the adoption, if it goes up on appeal, right? If the person appeals it, mm-hmm. and there's still a chance that they could get it reversed, it's not really complete. And it really does need to be handled and finalized before you move on with an adoption.
I think that's correct, and I think that's why, obviously, practitioners have historically been proceeding the way that they have by moving to appeal from the termination order and not entering the adoption decree because of this concern. And the other concern that this raises is, if you were to formalize the adoption decree, and then whether the termination order is appealed right after it's entered or if we're waiting until the adoption decree is final, if you have an adoption decree that enters before we have a potential reversal on the termination issue, then you have another kind of a procedural problem, or you've created a procedural kind of nightmare at that point, where you now have two sets of parents with constitutionally protected parental rights. And I think that's an area that I'm not entirely sure how the court would handle that, but that's a problem that the court doesn't have to create if we just deem that the termination orders are final. If there are no further questions, I will submit on the briefing. Thank you.
Thank you, Counsel.
I'm getting a very short version of supplemental briefing right now. Thank you to my colleague. So for the line that Your Honor was questioning about where the express language comes from, it does come out of nowhere in Meller. The case relied on was Powell v. Cannon, which is 2008 Utah 19. And in that case, the language was the statutory avenue for appealing non-final orders. So nothing about express language. And then going back from that, citing Bradbury v. Valencia, 2000 Utah 50, orders and judgments that are not final can be appealed if such appeals are statutorily permissible. So we're getting much less rigid language as we go back. And this is obviously the 20-minute version of the supplemental briefing, but that lends support to the idea that when we're talking about express exception in the context of finality, it is not as rigid as some other pronouncements of expressness that we've done, like for retroactivity and things like that.
Counsel, keeping in mind Justice Pierce's point about how we typically interpret statutes, and given what you've just said now about our prior case law, how would you articulate why the Court of Appeals below was, one, wrong to require an express statutory exception, and two, is this sufficiently express if we assume that that requirement operates?
So to go to one, it wasn't, the requirement of express language is not so rigid as to necessitate a direct pronouncement for every order that needs to be deemed final. So the use of the word final in the Adoption Act is enough to show the intent that that be appealable, because that's what the word final is generally understood to mean as a legal term of art. As to the second point, I think there's another side of the coin. So while we can look at it as perhaps the Adoption Act occupies this field and the legislature has occupied that space and we should not encroach on it with a finality rule, the other side of that is if we don't see that termination orders are final, we run into a slew of constitutional and due process problems, some of which my colleague talked about, some of which we talked about in our briefing in terms of the notice problems. One thing is very clear from the Adoption Act in terms of legislative intent is that they intended adoption order decrees to be as final as possible and almost unassailably final. There's statutes of limitation. There's limitations on who can challenge depending on what kind of participation you had earlier in the proceedings. There's limitations on what kind of collateral attacks can happen on an adoption order. This is different than other final orders. We don't have all of that scaffolding in place for other final orders because we want adoption orders to be as permanent as possible. And one of the most efficient ways to ensure that is to make sure that the underlying termination order is concrete, final, done, and it's not susceptible to an attack through an appeal that would undo the adoption. So in terms of legislative intent, I think we actually have a lot of support for the idea that the legislature wanted the termination orders to be just as final so that we don't have this area of weakness in the adoption decree, which is very obviously what the legislature did not want to happen. Are there any other questions? And we will submit there. Thank you very much.
Thank you to all counsel for the excellent briefs and oral arguments here today. We will take this matter under advisement.